Hi XOmniverse, I watched your video. Yeah, I did expect you to make a response. I was hoping you would. Here's my response to your response. Just an initial point. You had said at the beginning of your video that in my video I had tried to dismiss the entire anarchist, or the entire argument for anarchy by dealing with one argument. That is not the case. I expressly dealt with one argument raised by anarchists about Rand's philosophy, an argument to the effect that Rand's philosophy is internally conflicted or illogical, and that was based on an argument by anarchists. Not all anarchists, but many anarchists, including yourself and including Roy Childs, who said so early on, or proposed this theory early on, that because, on the one hand, Rand is saying that it's wrong for anyone to initiate coercive physical force, she is therefore wrong when she says that the government ought to have a monopoly on the retaliatory use of force. That whole video deals with that argument by anarchists. That video is not intended to be a categorical, dismissal of all anarchist arguments. It doesn't even address any other anarchist arguments. And I mean, the name of the video is In Defence of Ayn Rand, not in defense of, a monopoly for government. It's just about an argument raised by anarchists concerning specifically Ayn Rand's philosophy. I didn't particularly care to get into any other arguments offered by anarchists. So I noticed that in the comments section to my video, liberty is not given in particular, went on and on and on about how, well, you're ignoring this argument, you're ignoring that argument, you're ignoring the other argument for anarchism. That wasn't the point. The point of the video was to show that one argument about Ayn Rand's philosophy is flawed, and not one comment that I received in the written comments to my video dealt with that argument. In other words, not one of them said that my critique of the anarchist argument about Rand's philosophy, that my critique was in any way flawed. Instead, there were a number of comments, most of them from Liberty is Not Given, saying, well, what about this other argument for anarchism, and this other argument for anarchism, and irrelevant. I'm not saying they're right or they're wrong. The point of the matter is I wasn't even addressing them in my video, and in particular, I did not suggest that by addressing or criticizing this one argument made by anarchists, I'm somehow, addressing all of the issue regarding anarchism. So let's just put that to the side for a minute. Now, dealing with the substance of what you offered, which was an aside, really, I think, from what Rand had said. You're raising a new issue, I think. You start by saying, and I agree with you on this, that there are at least two senses in which the word objective is used. One is to say objective in the sense that it's derived from the facts of reality. Another is the word objective used in the sense of being impartial. So I'm totally on board. Yes, those are two definitions that are often used in connection with the word objective. They're not the only definitions, but certainly they are two definitions. You say rightly, I think, that rights are a moral concept. I don't know if you said that, but that's what you know based on your knowledge of objectivism and your agreement with it, from what I understand. And that rights exist independently of whatever the law says, independently of whatever a government says. I agree with you entirely there. Now then you say that you feel that people, even if they don't know it explicitly, that they agree for implicit reasons that every person, or that they have rights of life, liberty, and property. Well, first of all, I don't share your view that everyone agrees that they have rights of life, liberty, and property. I can't tell you how many times people have told me that there's no such thing as absolute rights, or etc. But more importantly, among those who do think that they have a right to their own life, their own liberty, their own property, most of those people don't operate consistently. So in other words, they say, well, yes, I have a right to my own life, liberty, and property, but then they suggest policies and ways the world should be, which would involve violating everyone else's life, liberty, and property. I'm all right, Jack, screw you, is basically the approach that most people take if they even get to the point of agreeing that they have rights of life, liberty, and property. And if, in fact, we all agreed that everyone has inalienable rights of life, liberty, and property, and if we all agreed, either implicitly or explicitly, that those ought to be respected by everyone, then we'd all be objectivists, wouldn't we? Because we'd all be grounded in reality, we'd all be reasonable, we'd all be egoistic. But as you know, we aren't all egoistic. In fact, most of the world is altruistic. Most of the world believes that obedience is the highest virtue, not rationality. Obedience to the word of an alleged God. And if that is your ultimate virtue, your highest virtue, it cannot be the case that you believe that you have inalienable rights of life, liberty, and property unless your God said somewhere in your holy book that you and everyone else has inalienable rights of life, liberty, and property. And I don't think there's a single religion out there preaching that. Certainly none of the Christian religions or Jewish various factions of Judaism or Islam. They're all, as you know, altruistic. And so none of them, altruism is not compatible with life, liberty, and property, and certainly mysticism is not, at least in practice. I don't know of any God that is the God of you have these inalienable rights. So, I don't think that's a realistic belief. And consequently, everything else you say about, well, because everyone sort of agrees that we have these rights of life, liberty, and property that ought not to be violated by anyone, then the law would just naturally evolve over time in a competitive system of arbitrations, and ultimately the law would reflect what everyone believes. Well, hey, if everyone believed in life, liberty, and property, and the inalienable nature of those rights, and that everyone had it, we wouldn't be having half the wars we've had for thousands of years. We wouldn't be having laws against, as you point out, marijuana use. We wouldn't have the religious right in the United States propping up the Republican Party. It just does not square with the facts of reality to suggest that people actually believe that everyone has inalienable rights of life, liberty, and property. Consequently, the law could not evolve from a society that allegedly believes in these things because they don't believe in these things. They don't believe in the inalienable and absolute rights of life, liberty, and property. They don't. It's the rare exception that do. What would happen if we just left it all to independent courts making decisions, leaving it all to precedent and a body of law developing over time? Well, guess what? We've done that already. It's called the common law in equity, and we've been doing it since 1066. It's not hard to figure out what happens when courts make decisions case by case and a body of law develops in accordance with the morals and beliefs of the judges, And it turns out that, what we've ended up with in the common law is not egoistic. It's rather altruistic. The whole field of equity is about breaching the concept of, a deal's a deal. A contract is a contract. Equity is about saying, well, not if it's unfair, or not if, someone's unfortunate, and maybe then we should bend the rules and redistribute wealth. The law has not developed in the courts outside of the lawmaking facilities of the legislatures. And a great amount of the law has never been modified by any elected politician, has never been drafted by any elected politician. A great chunk of the law, the common law and equity, is simply a bunch of written precedents, stories about how a judge listened to two sides and resolved the differences. In other words, just what an arbitrator does. The result has not been freedom. The result has not been a system of common law and equity that, respects the inalienable rights of life, liberty, and property being held by every individual. And this system has had a long time to evolve that way. It's been around since at least 1066. So here we are 1,000 years later, and we have a common law and equity system, a system of precedents, a system where it wasn't some elected officials elected by a majority vote who decided on some written laws. No, a great chunk of our law is not written anywhere except in the form of decisions made by judges. Now, keep in mind, what's the point of objective law? Well, so that every person knows in advance what is expected, what conduct is right, what conduct is wrong, what conduct will get you into trouble, what conduct won't, what will happen if you do get into trouble in terms of a penalty, and what won't happen in terms of a penalty. All of these things are aspects of what the law does for us. It puts us all on notice. Well, you couldn't pick a worse way to communicate what is expected of you than to leave it all to the decisions of courts, or, in your hypothetical system, the decisions of arbitrators. How does anyone understand what the common law or equity expects of them? Guess what? They pay guys like me thousands and thousands and thousands and thousands of dollars to help them through one single interpretation, one single problem they're having with the law that's written down nowhere. They can't open a book and just read it. It's not a statute of any sort. Rather, it's hundreds and thousands and millions of cases that people have been taught, which ones to look for, which ones not to look for, which ones cancel out which other ones. Years of study creates a lawyer that, to one extent or another, knows how judges are likely to go based on how they've gone in the past. But how they're likely to go is not written down in a code book. You can't, as a regular citizen, pick up a book and say, okay, here's what's expected of me in the field of contract law, in the field of torts, in the field of trusts, in the field of wills. These things are largely creatures of precedent, case-by-case decisions. Now, let's go back to the cases for a second. One of the reasons that the law can't be just understood by picking up a book is because the decisions conflict with one another. Trial decisions conflict. There's not one moral code or one set of laws out there. There are numerous judges resolving things their own way, conflicting ways, conflicting logic, differing moral codes, because judges come from all numbers of different moral backgrounds, religious backgrounds, non-religious backgrounds. They have all kinds of different views, collectivist, individualist, political, ethical, metaphysical, epistemological. They are a mixed bag, and most of them don't even have an explicit code or explicit philosophy that they're carrying around with them. Rather, they were students of law who got appointed to the bench, and quite often all they know about morality they got in church on Sunday or in synagogue, or from watching, issues of or episodes of, Barney Miller or Geraldo Rivera. You think I'm joking, but as you know, that is the case. Most people don't study philosophy. That doesn't stop them from becoming judges. So you've got a mixed bag ideologically of judges making decisions that are clearly in conflict with one another. And how do we resolve that? How have we resolved it for hundreds and hundreds of years? By having an appeal court, a court that's higher up the hierarchy. And when that appeal court resolves all of the conflicting decisions and says, well, this is the way it's going to be, all of the underling courts, all of the lower courts are forced, they're bound by precedent to obey what that higher appeal court said. And guess what? There's one. And it binds the decisions of all trial level courts. In fact, there are even appeal courts from which appeals can be appealed. And they bind all of the appeal courts. So for example, you have the Supreme Court of Canada, the decisions made by the judges in the Supreme Court are binding on all of the courts of appeal in the provinces, and those decisions by the courts of appeal in the province are binding on all of the divisional courts, and the decisions of all of the divisional and appeal and Supreme Court of Canada courts are binding precedent on the trial level. How, in a competitive system of courts, would you have a resulting system in which there was one court that imposed binding precedent on all of these other competitive courts? Again, you'd be accepting that there would be a monopoly, that the appeal court would have a monopoly over lawmaking. So here's your alternative. No appeal court. No binding precedent. Just an endless supply of conflicting decisions. There's no law in it. In fact, it would be the absence of lawfulness. Nobody would know which decision was going to be relied upon, which judge they're going to end up with. They might pick this judge because they know in the past he's decided to go this way, but if everyone knows he goes that way, the other guy on the other side who's not going to benefit from him going that way is going to want some other judge who goes the opposite way. It doesn't work. The only way you can have a system of law, an objective code of law, is for there to be one decision maker. Someone who says, all of that conflict has to end, here's the way it's going to be. And until there is one way, until there is one set of laws, nobody can know what's expected of them. You not only have anarchy, you have chaos. And that's the whole point. Rand's saying you have to have objective rules. And those, you can't have objectivity if everyone is providing conflicting answers on similar questions or the same question. So it doesn't work. Just leaving out the whole issue of appeal courts and etc., do you really want to replace a system where you can, look at a few, behind me I have 12 statute books that lay out all of the statutes ever written by elected officials up to the year 1990. They haven't done a consolidation since then, but up to 1990, all of the laws that existed up to that point that were still on the books were all condensed, all put in one set of books, 12 volumes. Well, guess what? Case law, all of those decisions made by all of those courts over the various decades and centuries, going back to 1066, all of which is binding precedent, if it hasn't been overwritten by higher courts in subsequent years. There are hundreds and thousands of volumes. I could only show you a tiny, tiny fraction from only one jurisdiction, only one or two publications in this library, the Ontario Reports, which every lawyer gets for free, which is an editor's collection. There's a board of editors that literally cherry picks cases from all of the hundreds and thousands of cases that get decided in this jurisdiction alone every year. They cherry pick 3 or 4 per week, and they publish them. At the end of the year, they maybe have 150 out of 100,000 cases that get reported. And despite the fact that they're cherry picking, and you don't even really know what all the other courts decided, other publications cherry pick different cases. Some go according to topic, some go according to the level of the court, whether it's Supreme Court of Canada. There's a Supreme Court of Canada reporter. There's a property law reporter. There's a criminal law reporter. It goes on and on and on. There are libraries that are stories high with literally, since the dawn of the common law, we're talking millions of cases. You expect people on the street in an anarchistic system to sort of get a feel or understand what the law is without hiring a lawyer? Effectively, what would have to happen for anyone to understand what their rights are is to have a lawyer on retainer and ask him, what's the law with respect to this? Well, based on the decisions, it's probably this way, but we can't be certain because judges are all different. That's true. When you hire a lawyer to defend you or to prosecute or to sue somebody in a court of common law, it's not a certain thing. It's about probabilities and likelihoods and what a judge is likely to do based on the decisions in the past, keeping in mind that the judge can pretty much do whatever he wants because he knows that as a practical matter you aren't going to be able to afford an appeal. There are all kinds of reasons why the precedents written by judges over the hundreds of years that have passed are not a good way of establishing an objective code of law. There's certainly no way, there's no practical way for an average person to know what's expected of them just by knowing that there are these thousands of or hundreds of thousands of volumes of law out there. Doesn't do them any good. You could read until the cows come home, you wouldn't know what the law was in the province unless you'd gone through 3 years of law school and a year of articling and then maybe a decade of actual practice in front of judges. It's not the case that a body of law would develop. We don't share common morals. We don't share common epistemology. We don't share common metaphysics. We certainly don't share common ideas about policy. And judges have all have differing ideas about it, metaphysics and epistemology and ethics and politics. And those have an influence on the decisions they make. And as a result, you end up with conflicting cases on similar fact scenarios. And you end up having to hire judges just to sort of figure out what the law probably is. That's what you get when you leave lawmaking to multiple tribunals, especially when they aren't even part of the same system. I've only talked about conflicts that exist in a single system. Imagine one company having a bunch of judges. That's what we've got, right? We've got the Crown in Canada and Britain. You used to in the United States. Since then, the people took over. But it's still the common law. And the fact of the matter is that, it does not serve the purpose of identifying in an objective, unequivocal way what is expected of you. And simply turning it over to private courts instead of public courts doesn't mean it would suddenly get magically better. In fact, it may even get worse, because there may be some restraints on judges in the single public system that would be off of judges when there were multiple systems of courts. It's not at all practical. If you want to turn, if you want to leave every person at the mercy of lawyers and judges for their entire life, never knowing what the law is, then all you have to do is take away the statute-making function of legislatures. And it doesn't matter whether those courts are private or public. What they create is something that the average person will never absorb, never be able to govern their life by. It will not be an objective code of law, even if there's some similarity on the political aspects of things. Because the metaphysics, the epistemology, and the ethics will always make the decision different. So, what's the phrase I'm seeing from some people when they talk, when I speak about objective laws or objective legal systems? They say, well, it's not grounded in reality. I'm sorry, but I've been practicing law for 10 years. And if anyone thinks that the common law is going to be a system for establishing objective codes of law by which people can live, or that even expanding that so that the common law is written by multiple private different law firms, or rather arbitration firms, that's only going to exacerbate the problem. So, can't agree with you. My experience tells me completely the opposite. Common sense tells me the opposite. But mostly, as you know, not everybody's an objectivist, and that should really be the end of it. I mean, if you understand that not everybody agrees that there's no afterlife with another world, an afterworld, if you understand that not everybody agrees that this is it, this is the only life we've got, this is the only reality, then how can you assume that people will, with these differing ideas about the nature of reality, come to the same interpretation of life, liberty, and property, come to agree that they all and each of them has inalienable rights of life, liberty, and property, that these rights are absolute? They cannot. They will not. You will not have a congealing of this law that bubbles up from numerous arbitrations. You'll just have a bunch of conflicting decisions and everyone in utter, misunderstanding, not understanding what's expected of them. That's all that can develop, unless someone, either an appeal court or an elected body that makes that drafts. Even an appeal court won't help you too much, because they will generate multiple precedents, many of which will conflict. That'll require lawyers to interpret them. Really, what you need is a code, a written code, legislation, and that can only be done by a legislature, which isn't in any way compatible with an anarchistic system. Anyway, I hope that addresses some of what you said. Hope I haven't mischaracterized what you said, but I think I've stuck to the critical points. All right, talk to you soon. Bye.